this Constitution Day lecture, but Constitution Day lectures all over the country. In a few days, I'm going to be hosting my own Constitution Day lecture at Pomona College. And the Jack Miller Center has really quietly done some very important things in enabling us to have these kinds of conversations, both on Constitution Day, in honor of Constitution Day, and far beyond it. I also want to say thanks in advance to Ben and Rebecca for whatever comments they offer, especially as long as they're nice. And I want to say thank you, especially to the Oglethorpe students who are here. I know there are people from far and wide on this Zoom call, but I did get the chance. I have been to Oglethorpe, and I know it to be a beautiful and lovely place that I wish I could be at right now, especially because although I'm struck by looking into myself in the Zoom screen, it looks like a lovely day outside, but there's ash raining from the sky behind me. Southern California is not exactly the dream place that you know, we sometimes think it is. So believe me, I wish I were there. In any case, let me start my talk here. So on July 4th, 1854, the Massachusetts Anti-Slavery Society held an Independence Day event. This event, which was held in the Boston suburb of Framingham, was advertised as being open to, and here I quote, all who are ready and mean to be on liberty's side. The Anti-Slavery Society organized this to be a massive event. So much so that special trains, and you can actually see that on this advertisement, ran from the nearby cities of Boston and Worcester and Milford to accommodate what the organizers knew was going to be an epic crowd. The crowd was epic, and the event was epic because most people in Massachusetts were still aghast at the events of the previous couple of months. Now, some of you may know this already, but without getting too far into the details, you need to know that two major things had happened in the months leading up to July 4th, 1854. The first thing is that in May of that year, Congress had passed the Kansas Nebraska Act. For those of you who don't know what that was, the Kansas Nebraska Act effectively permitted settlers to legally establish slavery in the Western territories of the United States, those yellow territories on this map here. Put in another way, the act basically undid the Missouri Compromise. After the Kansas Nebraska Act was passed, many abolitionists worried, not without reason, that the act had opened up the entire continent, even the North, even unthinkably Massachusetts, to slavery. The second thing that happened that same month of May of 1854 is that authorities in Boston seized a man named Anthony Burns as a fugitive slave. There were widespread and aggressive abolitionist efforts across the city to free him. But the US military swept into the city of Boston with artillery, with bayonets, and hauled Burns through the streets, back to Virginia and back to enslavement. The effect of both of these events enlivened abolitionist sentiment throughout New England. And so the anti-slavery organizers knew they would see a big crowd for their July 4th event. The advertisement that you see here again promises, quote, eminent speakers from distant quarters of the state, which from our historical perspective seems like more than a bit of an undersell, because the speakers of this event included some of the most famous names in American history, including Sojourner Truth and Henry David Thoreau, right? Imagine an event with Sojourner Truth and Henry David Thoreau, whose book Walden had only recently been published, and even they aren't the top billing at the event, right? Even with that kind of star power and force, the top billing of the day went to William Lloyd Garrison, one of the founders of the American Anti-Slavery Society, and a man who was and probably is still most famous for publishing the popular anti-slavery newspaper, The Liberator. Now, to give you some idea how important Garrison was at this event, even with Sojourner Truth and Henry David Thoreau hanging around, I have trouble wrapping my head around that fact by itself. The organizers of this July 4th event had set up a stage with two banners on it. The stage itself was draped all in black, the color of mourning. And the two banners hanging up, one said on one side of the stage, Virginia, One said on the other side of the stage, "Redeem Massachusetts." And between those two banners, an American flag hung upside down, right? And just before the day's speakers ascended to the stage, someone jumped up and put a picture of William Lloyd Garrison on the middle of the stage, so that Garrison's picture symbolically broke the connection between Massachusetts and Virginia, and more broadly, the connection between free and slave states. Of course, this also meant that Garrison's face literally obscured, sort of literally defaced the American flag. Garrison was at the center of things. Well, when, my computer doesn't like me anymore. Let's see if we can get this back. PowerPoint. Exciting. Let's see if, we'll use that. Okay, well, when after much anticipation, Garrison took to the stage, he came onto the stage in a fury. Now, there aren't any pictures of this event because it's 1854. There weren't really pictures at the point in time. All the accounts are talking about is fury. This is the only drawing I could find of the event, and he looks like sort of gentle in the picture. So you need to a little imagine the fury here, right? Today, he intoned, "We are called to celebrate the 78th anniversary of American independence. In what spirit?" he asked. "With what purpose?" he asked. "To what end?" he asked. The Declaration of Independence, Garrison said, was premised on the idea of human equality, and therefore was fundamentally at odds with human slavery. And yet, human slavery was the law of the American land. As such, any celebration of the Declaration of Independence in the United States was either 1, a celebration of a lie, or 2, a celebration of the stupidity and blindness of white Americans who somehow managed to believe that their laws, which authorized human enslavement, somehow really supported human equality. After saying that, Garrison produced a copy of the 1850 Fugitive Slave Law and put a match to it. The crowd clapped as the document burned. Then Garrison, brought out a copy of the order to send Anthony Burns back into slavery. That too, he set aflame, and the crowd cheered. But Garrison wasn't done yet. For his final act, he held up a copy of the United States Constitution. He called the audience to look upon it and said, "This is the source and parent of all the other atrocities, a covenant with death and an agreement with hell." And then he burned to ashes the Constitution of the United States. He did it while yelling, "So perish all compromises with tyranny." He burned the United States Constitution down, and the crowd roared. Let's take a step back here. If you watched the third night of this year's Republican National Convention, and I will definitely forgive you if you did not, you'll know that it started out with a tribute to the wisdom of the American founding. And in this flag-wavy tribute to the wisdom of the American founding, the very authoritatively voiced narrator talked about how in the 1800s, anti-slavery activists embodied the spirit and fidelity to our American founding. Now, whatever you thought about this year's RNC, and this is this kind of screenshot from that opening segment, that the fight against slavery was a fight on behalf of the principles of the American founding and in fidelity to the American founding. I think that's an idea that's pretty commonly held in America, right? Even in this time of what many rightly feel to be polarized politics, it's certainly a sentiment that would be just as home in the DNC convention as in the Republican National Convention. Those who fought slavery were fighting on behalf, most of us tend to understand, of the ideals of the American founding, in fidelity with the American founding, in fidelity to the ideals of equality and freedom, in fidelity to the Declaration and the Constitution. And indeed, that is how most abolitionists, including William Lloyd Garrison, saw it, especially in the first years of real anti-slavery agitation in the 1830s. At that point in time, most anti-slavery advocates believed that the institution of slavery wouldn't survive in the face of the nation's founding documents. As one commentator has put it, abolitionists started out by assuming, as many of us still do, that the founding fathers had intended to ensure the quiet death of slavery over time. Abolitionist groups like the Massachusetts Anti-Slavery Society even spent a lot of money just publishing and distributing copies of the Declaration and Constitution, thinking that anyone who read them would see them as anti-slavery documents. But then, in the early 1840s, James Madison's notes from the Constitutional Convention were published for the first time. Right? Before the publication, they had looked like this. Nobody had ever really seen them. But those notes, once published, revealed that although some of the framers, like Madison, thought that slavery was, quote, dishonorable to the national character, none of the anti-slavery delegates in the convention, with maybe the exception of people like Connecticut's Oliver Ellsworth, who I know you've never heard of, called for prohibition of slavery to be written into the Constitution. Instead, they deferred to the Southern pro-slavery delegates who argued that the Constitution was a political union, not a moral union. In other words, many of the abolitionists who had believed in an anti-slavery interpretation of the Constitution saw in Madison's account that the founders had traded union and white liberty for Black slavery. Subsequent judicial and legislative decisions, such as the Supreme Court's 1842 decision that federal agencies had to carry out fugitive slave laws, Congress's passing in 1850 of the Fugitive Slave Act and the 1854 Kansas Nebraska Act, seemed to mock the idea that there was anything about the United States Constitution that was anti-slavery. For his part, William Lloyd Garrison looked at the wicked pro-slavery laws being passed by Congress and legitimated by the Supreme Court in the 1840s and 50s, and decided that he couldn't conclude anything other than that the Constitution itself had enabled those laws, that the Constitution itself was responsible. Not only wasn't the Constitution anti-slavery, he decided, but it was a document that was fundamentally pro-slavery. The Northern framers, he decided, had made a deal with the devil to craft the Constitution, Garrison thought, a deal that went so deep that the devil himself could not be exorcised from it. The only remedy, Garrison exclaimed at the close of the July 4th ceremonies, is a dissolution of the Union. Now, William Lloyd Garrison's anti-Constitution position wasn't representative of all abolitionist thinking. Far from it. Many, if not most, anti-slavery activists held to the position, at least in public, that the Constitution was an anti-slavery document at its core, or at least could be interpreted to be so. But in the last year or so, thanks in part to a student of mine who's actually on the Zoom today, hi Adam, I've become fascinated by those prominent abolitionists who, in the 1840s and 50s, turned against the Constitution. So I'm basically going to subject you to that fascination today. Now, I'm fascinated by these guys in part because they're contrarians, and I like contrarians. I tend to think that contrarians can teach us a lot about everything. But more than that, I'm fascinated by these guys because I think that their stances against the Constitution can tell us a lot about the Constitution. Not just the Constitution before the Civil War, but the Constitution today. So, in honor of this year's Constitution Day, I'm going to do three things in this talk. First, I'm going to ask you just to keep that story about Garrison that I told you in mind. Second, I'm going to tell you another story of an abolitionist fighting against the Constitution. And third, I'm going to offer up some thoughts about how all of this might help all of us better understand the Constitution in our own time. So, part two. Perhaps the most famous story of anti-slavery opposition to the United States Constitution starts in January of 1858, when John Brown, who of course would later go on to lead an armed rebellion against slavery at Harper's Ferry, traveled to Rochester, New York, to the home of Frederick Douglass. Now, you've probably also heard of Frederick Douglass, the escaped slave whose autobiography catapulted him to the front of the abolitionist scene, nationally speaking. Now, this is a few years, if you're doing the math, right, after the Garrison incident I told you about. And in the interim, abolitionists had grown even more despairing. That's largely because in 1857, the Supreme Court had issued its famous decision in the Dred Scott case, holding that the United States Constitution was not meant to include citizenship for Black people, regardless of whether they were enslaved or free. And we actually know something now about that decision that nobody knew then, which is super interesting, not super germane to this talk, but so interesting I have to say it anyway, which is that then President-elect James Buchanan of Pennsylvania had behind the scenes pressured one of his northern friends on the Supreme Court to join the Southern majority in that decision in the hopes that the Dred Scott decision would quell unrest in the country over slavery. That, I think we can agree, was a miscalculation, because of course the opposite happened. Abolitionists despaired, they raged. The court's decision, for understandable reasons, radically increased abolitionist animosity to the Constitution. So anyway, John Brown went to Frederick Douglass's house and spent 3 weeks there. And from what we understand, Brown spent almost the entire time in his room writing. What he was writing was a new Constitution for the United States. And let me just read you the preamble. It's a little hard to read on the slide, so you can get a sense of it. Whereas slavery throughout its entire existence in the United States is none other than a most barbarous, unprovoked, and unjustifiable war of one portion of its citizens upon another portion, the only conditions of which are perpetual imprisonment and hopeless servitude or absolute extermination, in utter disregard and violation of those eternal and self-evident truths set forth in our Declaration of Independence. Therefore, we, citizens of the United States, and the oppressed people who, by a recent decision of the Supreme Court, are declared to have no rights which the white man is bound to respect, together with all other people degraded by the laws thereof, do for the time being ordain and establish for ourselves the following provisional constitution and ordinances, the better to protect our persons, property, lives, and liberties, and to govern our actions. Now, John Brown's provisional constitution roughly followed the form of the United States Constitution, with a legislative, executive, judicial system of checks and balances, but with some important differences. This constitution didn't just outlaw slavery, although it did that. It also insisted on a right to education, a right to open carry weapons. In fact, there's the powerful suggestion that all Americans are obliged to open carry weapons in the John Brown Constitution, and a right to marriage and family. All of those rights, of course, being rights that are both A, nowhere articulated in the 1787 United States Constitution, and B, rights that were being systematically denied to Black people in the United States. The whole document was designed to set into relief what Brown saw as the fundamental wickedness of the standing United States Constitution, with not only its indirect acknowledgement of slavery, but also its failure to articulate key human rights. Well, after Brown wrote this provisional constitution, it was discussed quietly in abolitionist circles with an eye to future action. Then, in early May 1858, John Brown crossed the border into Canada with a group of other abolitionists. Most notably, one of my favorite people, the truly important but almost totally neglected Black abolitionist, Martin Delaney, for a constitutional convention. The choice of location in Canada was meaningful because tens of thousands of fugitive slaves lived in the region, and Brown thought that no American constitution could ever be legitimate unless it were the product of deliberation between Blacks and whites alike on equal terms. In the end, 34 Black men and 12 white men participated in deliberation over the Provisional Constitution and ultimately signed their names to it. After John's Constitution was signed, they didn't talk about it much, but he used it quietly behind the scenes to recruit and fundraise for what would become his disastrous raid on Harper's Ferry. Brown used the Constitution to get both financial and political support from both white and Black abolitionist leaders. This provisional constitution presented abolitionists with a glimpse of a different society, one which replaced the dehumanization of slavery with a system of equal citizenship across the color line. Although it's really hard to know what abolitionists talked about amongst themselves, because boy, let me tell you, those Underground Railroad trained abolitionists were good at keeping secrets. Oh my goodness. But one of the things we know that Brown did with his Constitution was to take it to Harriet Tubman as a way that convinced her to help him recruit freed slaves for the raid on Harper's Ferry. Even amid all this political activity, John Brown's Provisional Constitution remained a secret to most outside the circles of activist abolitionism. It was only after his attempt to inspire a slave insurrection at Harper's Ferry failed that authorities discovered a substantial number of printed copies in John Brown's possession. Presumably, Brown and his compatriots had prepared those constitutions to distribute after a victory that, for them, never came. And I just want to mention in passing here that I was struck today when I was checking the dates here that the raid on Harper's Ferry is mid-October 1859, and John Brown is executed 6 weeks later, right? Like, John Brown doesn't have an extended trial, right? Like, all of this happens really fast. I sort of thought that was interesting. Of course, victory for the abolitionists did come, if you can use the word victory in the context of a gruesome civil war that pitted countrymen against countrymen, friend against friend, family against family, and killed 2% of the American population, right? To give you some perspective, that's like if something happened that killed 6.5 million people today. It was a terrible, if perhaps necessary, price to pay to end the legal enslavement, that is the legal torture, rape, and manifold dehumanization of the people by the people. Now, to enshrine the outcome of the Civil War into law, legislators decide that they needed to pass the 13th, 14th, and 15th Amendments to the Constitution. In large measure, I think it's unarguable that the existence of those amendments, and here's where I get into sort of conclusions we can start to draw. I think it's unarguable that the existence of those amendments to some degree vindicates the views of Garrison, Brown, and other abolitionists that the Constitution as originally penned was, if not explicitly pro-slavery, insufficiently anti-slavery. The existence of those amendments, while not uncontroversial in their time, by the way, if you haven't seen it, if you kind of want to see this played out in a pretty good way, I think that Steven Spielberg's film Lincoln does a pretty good job of showing this. While it wasn't uncontroversial, the decision to amend the Constitution seems to show that most legislators were convinced after the Civil War that a simple return to the original text of the Constitution was insufficient to memorialize so much that had been given by so many to end slavery and preserve the Union. Now, John Brown wasn't alive to see those amendments passed, having been executed for treason in 1859, but Garrison was. And it is telling that once those amendments were passed, Garrison's tune on the Constitution changed. After those amendments were passed, he certainly never held the Constitution over a candle again. And this gets me to the core of what I think we can learn from the anti-slavery, anti-Constitution folks of the 1840s and 50s, that almost paradoxically, their opposition to the United States Constitution reveals to us the strength of American constitutionalism. And I mean that in some very specific ways. For one thing, that Garrison could burn the Constitution down in 1854 and then celebrate it in its amended form 15 years later testifies to the fact that the Constitution, as originally designed, is a much more resilient document than we often think or even want to think. Garrison in 1854 couldn't have imagined the Constitution of 1870. Now, I trust, though, Professor Knickenberg has told me ahead of time that he has failed you on this Count Oglethorpe students, but I had hoped that he had made at least some of you read the great conservative thinker Edmund Burke, who famously wrote, here's Edmund Burke, but, oh, no, there he is, that states without the means of some change are without the means of their own preservation. I'm gonna say that again because that's important. States without the means of some change are without the means of their own preservation. Fewer smarter things about politics have ever been written. A conservative document in the proper sense, one that can endure, that one that can be worthy of enduring over the long term, has to have built into it some flexibility, some room for change and growth and even evolution. In the case of the United States Constitution, the power of amendment is perhaps the greatest testament to the wisdom of the founding fathers. For even if Brown and Garrison and others were right that the 1787 Constitution failed to live up to the highest ideals of the nation by a long shot, the framers were smart enough to incorporate into the Constitution itself some means for its transformation. And let's be clear, that's what the 13th, 14th, and 15th Amendments do. They transform the nation. It's a revolution. They don't just get rid of legal slavery, although they do that. They also redefine the terms of citizenship. I'm just going to talk to you about one change that's really important. The 14th Amendment defines citizenship in the United States as decisively a national question. all persons born or naturalized in the United States are citizens of the United States and of the state in which they reside. State citizenship. Your status as a citizen of Georgia or Pennsylvania or California or wherever is now defined as a subset of national citizenship. This is an almost revolutionary change. Before the Civil War, it had worked the other way around. You're a citizen of the United States because you're a citizen of Virginia. Before the Civil War, states are the definers of citizenship for the most part. The federal government has rules of naturalization, but in terms of defining what makes you a full-fledged citizen, it's largely a state question. Post-Civil War, this is a national question. And the national government correspondingly, even though it didn't do much about this for a very long period of time, and arguably not quite yet in full ever, acquires a whole new set of constitutional powers to protect your rights as a citizen against the state. The 14th Amendment has a clause in it that says, and I don't think most Americans know this, any state that does not protect the rights of its citizens, including the right to vote, shall have its representation in the House of Representatives reduced. If you don't let people vote, if you disenfranchise them, we'll cut down the number of seats you're entitled to in Congress. This isn't a may, this is an imperative. Right. Now, to be fair, guess how often that clause has ever been invoked? Never, nada, not once. But the fact that that clause is there transforms the terms of debate. We're debating it in this election year still. Now, if you follow debates about constitutional interpretation, and I'd forgive you if you don't. You'd probably know that the contemporary debate tends to pit on one side, conservatives who side with the so-called originalist interpretive strategy, sometimes called strict constructionism, and liberals who think we should treat the Constitution as a living document, a position sometimes called loose constructionism. To caricaturize these positions, the conservative position is something like, when we make decisions about constitutional law, we should do so with primary attention to the words and intentions of the framers, right? By contrast, the liberal position is, when making decisions of constitutional law, we should treat the Constitution as a document whose meaning evolves and changes over time and adapts to new circumstances without formal amendment. Now, to put it all together, if you keep all that I've told you about Garrison and Brown in mind, I think that you should see that the most rigid variation of both of these schools of thought is woefully inadequate. Because if we take originalism seriously, as I think we should, we have to recognize that the original intent of the framers was to provide a very specific means of constitutional change, the amendment process by which the Constitution could be transformed. And once an amendment is passed, its position in the Constitution isn't second rate. It has the same legal standing as the original text. It can supersede the original text, right? The 3/5 clause is no longer in the Constitution. The 13th, 14th, 15th Amendments are. And I think that Garrison and Brown's stories on the other side also showed us that treating the Constitution like a living document that naturally evolves without amendment is actually a pretty chancy and dangerous proposition. As Brown and Garrison saw, leaving the Constitution up to interpretation by whoever happens to be in charge of the courts at any given moment subjects the document to rather arbitrary rule by whoever happens to be a judge and whatever they happen to think at the time. Rather than insist on such dangerous presentism, because as many of my progressive students think, the only alternative is to accept what they see as white supremacism of the 1787 Constitution, we might properly understand that an originalist reading of the Constitution doesn't just shoot us back to 1787 and leave us beholden to slaveholders. In this case, it shoots us back to the post-war amendments, which the original anti-Constitution abolitionists like Garrison saw rightly as a fundamental transformation of the Union and of the Constitution itself. To my mind, Garrison's story by itself shows the impoverishment on the one hand of those who associate originalism entirely with the 1787 drafting, and the impoverishment of those on the other side who think that the Constitution is a amorphous living document. The Constitution, in truth, is neither entirely fixed nor entirely malleable. Rather, it contains within it a careful and fixed means of its own transformation, its preservation by its change. It's thus both a conservative and a liberal document, careful in setting terms, but not without recognition of the right for each generation to reconsider it and take ownership of it. If we think about John Brown, another aspect of the strength of American constitutionalism becomes clear. And I should say here that I'm following here the argument of the great scholar Robert Sy. Stealing his argument would probably be a fairer way of putting it. If you want to read a really great book about American constitutional history, read this book, America's Forgotten Constitutions. In any case, part of what's striking about John Brown's rejection of the US Constitution is that his objection takes the form of writing another constitution. And that provisional constitution looks a lot in form anyway, like the original Constitution. We have to understand John Brown's rejection of the American Constitution within the fact that he's clearly a supporter of American constitutionalism. That set of ideas that says, we should have a constitution. It should be written down. It should be a brief statement that serves as a guide to the creation and judgment of future laws. It should address governmental form. It should include some set of checks and balances on power and so on. I want to say that Americans, this is so baked into the way that Americans think that we take it for granted, but that's no small thing. This is certainly not a set of assumptions that has guided most societies in human history. Sy calls this in his book, the ideological domination of the American Constitution. That is, even Americans who were inspired to resist the American Constitution tend to do so within the terms of American constitutionalism. In trying to resist the Constitution, they tend to remain steadfast in their commitment to and recognition of the underlying principles of constitutional rule. Another good abolitionist example along these lines is Frederick Douglass, who says at one point that despite his own ambivalence about the 1787 Constitution, he wouldn't want to burn it, because as he saw it, the absence of a written constitution would be far more dangerous to Black Americans than the flawed constitutions they already had, right? A bad constitution is better than no constitution. As Sy says in his book, that even the most radically aggrieved, we'll come to him in a minute, radically aggrieved Americans can still muster faith in the constitutionalist core of the American political tradition, should be a glimmer of hope about the possibility of American constitutionalism to absorb and help us negotiate even major differences among us. In this time when most of us are lamenting the disunity and discord that seem a signal feature of American politics, this is really something important to remember. And let me just note in passing that this underlying commitment to constitutional is still evident today, both on what we might call the aggrieved radical right? People like Cliven Bundy, right? Cliven Bundy himself, you can see the Constitution in his pocket in this picture as he's advocating his radical hoo-ha, right? And on the aggrieved left, and I don't know how many of you follow the Black Lives Matter movement closely, but BLM activists have a whole set of principles of how they'd like to change the American Constitution, right? And they have all sorts of alternative constitutional amendments and structures proposed. You can check them out if you want. That is, even today, right, people who see themselves as really on the fringes or making complaints on the American constitutional system are doing so within the terms of constitutionalism. They're appealing to constitutionalism. Let me add one more thing in here before I end and we move to commentary and questions. There's some recent scholarship in political science about how moments of debate around constitutional amendment are good for the health of the Republic. Those moments of debate help remind Americans that we have some collective agency over what is in the Constitution. The Supreme Court only interprets it, right? We collectively have the power, at least some power, to reauthor it. Those moments of debate also help to teach people more broadly about what's in the Constitution, what's not in it, and what we might put in it. I think the same thing might be said about what the anti-Constitution, anti-slavery folks did. They provoked a lot of debate, both within and outside of abolitionist circles, about the nature of the Constitution, its relation to and dependence on the principles articulated in the Declaration of Independence, its aspirations, its advantages, its liabilities, and so on and so forth. In other words, those guys, even though we might be tempted to dismiss their kind of radical anti-constitutional actions as radical or reckless, actually helped to contribute to public debate about the Constitution, which helped to contribute to the civic education of the American people. Their opposition to what was claimed under the mantle of we the people. Their opposition that was couched in those terms, that is, helped to create a more engaged American people, even if that engagement took the form of debate and contestation. After all, we can't really be a we the people unless we talk and negotiate about what that means. Democracy entails disagreement and the difficult movement through that disagreement. So today, we are in what is without a doubt a difficult moment in American history. But as Adam knows, as I like to remind my students, this is not, as many like to claim, the most contentious time in American history. It's just not. Nor are we facing the most difficult issue we've ever faced in American history. Our own disagreement and divergence pale in comparison to the whiplash and division and violence this country experienced in the years leading up to and during the Civil War. And among the many reasons to study that whiplash and division and violence of that period is that in studying that period, we can find resources about how, even in moments of great division and resistance, we Americans have been bequeathed a constitutional inheritance that provides us with far more commonality and far more power than we usually allow. So thank you so much for having me here in this pixelated space with you all, wherever it may be, and have a happy Constitution Day. I look forward to your comments, Ben and Rebecca.
I'm going to ask Rebecca to go first and Ben to go second.
Okay. Thank you very much, Dr. Barndt. I really appreciate it. I learned a lot from this, and I look forward to learning more in the question and answer. I know students have a lot of good questions to ask, so I want to keep this brief. I wanted to just summarize what I took to be the thrust of your argument and make sure I've got it right. And then I have one kind of open-ended follow-up question. I would like to try to be a contrarian because I also like contrarians, but I'm afraid you've presented a challenge for me on that front. But I have something I can put out there. So it sounds like you're saying that the Constitution of 1787 was neutral with respect to slavery, which is to say it was unforgivably neutral with respect to something that was intolerable from the standpoint of the abolitionists. It didn't actively promote slavery or sanction it, but it also didn't take any steps to abolish it. So it tolerated the intolerable for the sake of unity. And basically the founders kicked the can down the road. Yet it contains the mechanisms for correcting its own inadequacies through the amendment process. And the fact that the abolitionists used it to correct the document's neutrality with respect to slavery actually redeems the original Constitution. It proves that it was enough in some sense because it was resilient, as you put it. The Reconstruction amendments were made possible by the Constitution with its capacity for change, and they allowed the document to be better harmonized with the Declaration of Independence, with its principle of human equality. It did take a violent insurrection, of course. It didn't, but the Constitution itself, amazingly enough, didn't need to be one of the casualties of the Civil War. There were other copies besides the one that Garrison burned. So it made it through alive, and perhaps even, and certainly even stronger, because it contained the tools for its own self-correction over time. You called it both liberal and conservative, or it provided for conservative progress. That is, it's conservative in that it's not easy to change the Constitution. It takes a super majority of elected representatives and the states to do so. It's not easy, but it does happen. And it's liberal in that the document was not written by people who presume themselves to be infallible, to have the last word to say on what would be a good system of governance for the United States. And they presume that future generations should have the opportunity to make their contributions. So I agree with you in this. I'm trying hard to disagree with you in this, but that that it did provide mechanisms for its own correction that were not what Jefferson would have liked. Of every generation people can just start from scratch, but there are possibilities to correct perceived deficiencies over time, and. You also argue with, or follow Richard Sy in arguing that, and I think rightly, that American critics of our political order on both the left and the right, both antebellum and contemporary, can't help but draw on constitutional principles precisely in the moment when they criticize it. Whatever criticisms that an American makes of America draw on American principles, either the moral principles of human equality and individual rights in the Declaration of Independence, or the political principles of the Constitution, of limited, institutionally balanced government that cares about following proper forms. And I just would point out, this isn't really a contrarian point, but my fascination is that there is this strange symmetry between the Confederates and the radical abolitionists, and that they both want to do away with the Constitution as it is. The Confederacy, of course, wrote its own Constitution, which is also markedly similar to the Constitution of 1787, with different exceptions that they make, right? With the explicit naming and protection of slavery, as well as trying to address the tariff issue. And so there's this symmetry in that they both thought that the founders got it wrong. Alexander Stephens, the Georgian, said, bless their hearts, they thought all men were created equal. Science has taught us new things now, and we know that they were mistaken. So they both rejected the founding document as fundamentally flawed and thought it needed to be rewritten. But of course, the abolitionists were able to rewrite it with the Reconstruction Amendments. And if you want to be reminded why it was worth fighting the Civil War, take a look at the Confederate Constitution to see what the alternative might have been. The question that I want to ask you is what I think is of interest to students based on the couple of questions that I've seen here, which is to make some connection with what you're saying to the challenges that we're dealing with today. I agree, it's not the 1850s, but that's kind of small comfort for me, that it's not as divisive as a time as the lead up to the American Civil War. I don't take much comfort in that. So I wondered if you could discuss what you see as one of the possible challenges to the Constitution's resilience that you worry it might face in November, and thus that we, the hopefully also resilient authors of the Constitution, might face. And do you have anything to offer us a little bit of hope for constitutional resilience in the face of the crises that I don't know if they're on other people's minds as possibilities, but they're certainly on my mind. And I don't know if you want to answer these now or if we could do Ben's response first.
Let's do Ben first, and then we'll let Susan take a crack at responding.
And I'm keeping track here of some of the student questions to raise after.
All right, first I just want to thank you for inviting me to participate in this. It's amazing what's possible now with Zoom. It's kind of neat. So for everything else that's gone wrong, there's something that's now right. But I don't have much really to disagree with in this talk. So I'm going to put forward some of my own thoughts and I think end with an actual question. In the first place, I think it's especially timely, thinking about these abolitionists, insofar as it reminds us of the issues where, so the statute debates we're not right now thinking about in the last several months. I think in particular it reminds us that there's always been a tear down the statues component of American politics, William Lloyd Garrison's public burning of the Constitution as an agreement with hell was shocking in some of the same ways that tearing down a statue of one of the founders is shocking to us now. That is, the Constitution, abolitionists like Garrett, we should be reminded that there's always been a kind of discordant, non-reverential element in American politics, which is kind of interesting to me. Part of the American spirit is in a way to hate America. And I think it's not all that surprising. A country based on principles, it's not surprising that it engenders hatred from its own citizens, either toward those principles on the one hand, or toward it for failing to live up to those principles on the other. Garrison and Brown hate America for failing to live up to its principles. But I think Garrison and Brown, and this points to the question I'm going to end up getting to, also teach us how impotent that non-reverential faction often ends up being. They don't really get anywhere in destroying the institution they detested. Slavery persists despite their valiant efforts. Perhaps at best we can say that Garrison and Brown brought the issue to the forefront in a way that it hadn't been in the prior 40 years of the antebellum period of American history. In saying this, I wouldn't suggest that it's unimportant, but it's at least not as successful. So one of the questions I want to ask you, Sue, is how much of an effect you think they actually had. But first, I mean, I think what's interesting to me here is how one uses the Constitution and American history. Abraham Lincoln finds in the Constitution and the Declaration themselves the inspiration for his more limited version of an anti-slavery movement. And this, I say, I've actually come to think that Garrison was in a way closer to the truth. The Constitution was, at least in a certain way, pro-slavery. I love Lincoln, so I hate in a way saying this, but I think he overstates and perhaps even lies about the extent to which the Constitution and the founders were anti-slavery. In other words, I'm not sure Garrison was wrong and Lincoln was right, but Lincoln creates a narrative that justifies an anti-slavery position within the confines of American reverence for the founding. That is, I think Lincoln teaches us something about the American taste for change that's somehow at the same time rooted in the past and reverence for the past. Even as he may have transformed the meaning of the Constitution, Lincoln claims merely to be restoring its proper meaning. Along these same lines, consider the difference between, on the one hand, sort of the early progressives who wanted fundamentally to transform American politics and the Constitution that undergirds it, and on the other, FDR's new Bill of Rights. They claim merely to restore, although extending some, the rights that had always been guaranteed in the American political tradition. So I think there's something impossible in American politics about Garrison's call. Americans just don't have a taste for that kind of fundamental transformation. Americans like change, but change weirdly rooted in tradition. Every change is somehow a return. When we change, we return. At the same time, we change. That every president both runs for change and runs for return at one and the same time. So I wonder, this all leads me, what kind of political effect do these kind of radical abolitionists have? How much of a hearing do they have? And how much do you think they set the stage for the politics that led to the Civil War? So thank you, though. It was a great talk.
Thanks to both of you. There's a lot that I could say here. I'll try to say a few things and then probably not address all the things so that I can get to the student questions. Ben, I think where you ended reminds us of a kind of paradox that's central to American politics, which is the paradox of living in a country whose tradition is rooted in a story of revolution, right? What does it mean to be attached to a tradition of revolution, right? I tend to think that it means that all Americans are both more conservative and more liberal than we tend to think, right? That we're both a mess of those two because we're both attached to the tradition, but we're also attached to the revolution because they're one and the same. I'm going to get to your question, Ben, but I'm going to, I think, respond to one of the things that Rebecca said first. One of the things that I've been noticing, if you look at the history of constitutional amendment, there tend to be these long periods of time where nobody's exercising that power, right? Where there's just no amendment. And then we get these bursts of decades where it's like the American people all of a sudden rediscover that they can amend the Constitution, right? The last such period of time was basically between 1961 and 1971. There's these whole series of amendments. And then, but from where we stand now, we're definitely in one of these long periods of non-amendment. It's like Americans have forgotten that we have that power. The last amendment was passed almost 30 years ago, and that's an amendment that was proposed, I kid you not, 203 years earlier, right? It wasn't like a new wellspring of a public movement, right? And so, you know, one of the things that you know, that I've started to think is that perhaps Americans in our current moment have in some ways done what has happened in the past, where we've in some ways sort of forgotten that that power is there. We see both on the part of the legislature, the Congress, and on both the part of presidents, a kind of deference to the judiciary. That is, Trump says, elect me, not because of what I'll do, but because of who I'll put on the Supreme Court, right? And Joe Biden says in some ways the same thing. And there's lots of documentation in political science that says, well, members of Congress defer to the judiciary all the time because rather than me coming out with a position on abortion that's going to alienate somebody in my district, I'm just going to say, well, the court decides that, right? And the American people, I think, have come to see the Supreme Court as like the be-all, end-all of American politics, which forgets the fact that we have the power of amendment to set the terms by which the court can decide. So part of one of the things that I look for in the next few years, and maybe even sooner than that in American politics, is do Americans rediscover their power of amendment, right? I think if we saw that, it probably would be a healthy sign for our politics. I think any period in American history where we get too far from some kind of amending energy, and as Sean Weinberg just wrote a book about prohibition. And one of the things he says in that book is like, you know, even if amendments don't get passed, simply debating the possibility that there could be an amendment is really good for Americans because it reminds us of our essential democratic power. So that's something that I sort of look for, that I'm worried about when I consider the current moment, that we're in one of these periods where we seem to have forgotten that power, and I'd look for that in the future. I also, thinking about what Rebecca says, right, like part of why I say, hey, remember it's not as bad as the Civil War, is because there is so much apocalypticism in our contemporary political rhetoric, right? You turn on the news any day and somebody is telling you that like everything in human history rests on us casting votes in one way or another in the next few weeks. And I don't mean to say that this isn't an important election or an essential election or election that will determine lots of other things. But I think we can become sort of overstate the apocalypticism of the moment. And I think when we get into those periods of anxiety and fear and apocalypticism, it's counterproductive politically, right? To think politically, I think, means being able to have some, you know, some greater sense of possibility. Dissent is, of course, a sign of a healthy republic. The last thing I did before I got locked into my house in early March was to go to a conference at Arizona State University where Bill McClay, the historian I like a lot, said, look, we should, anytime we see people dissenting in this country, we should celebrate it whether or not we agree with it, because if you're celebrating on the streets, that's a sign of a healthy constitutional republic. My variation on that in this talk is, as long as the factions that are aggrieved in the United States are talking in terms of laws, in terms of constitutions, like I sleep easy at night. The day we get to a point where somebody, you know, like stands on, I don't know, the Capitol building with armed rifle and says, fuck all constitutions, fuck all written laws, right? Like this should be, like none of that matters. That's a dangerous kind of dissidence. I will say in passing, because I, can't go for a whole talk without, at least occasionally taking a dig at Republicans. It should worry Republicans that one of the things that happened at the Republican National Convention was that the party did not write down a party platform. The party voted to say, our platform is whatever the leader wants it to be. That's dangerous. I mean, to me, that's a much more worrying sign than any protest in the street by right or by left. I think that kind of stuff should worry you, as long as in a big society like this one, you need written laws and you need that kind of underlying spirit of constitutionalism. And so, as long as we're paying attention there, I think we're mostly okay. To answer Ben's question briefly, how much effect did they actually have? Well, I mean, I think they have lots of effect, right? It's not immediate political effect. And I think when we're thinking about politics, we have to always remember, I know that the political scientists here know this, right? That you don't measure your impact in the immediate months following your action or even in your own lifetime necessarily. Brown and Garrison have huge impacts on American politics. Some of them are shorter term. One of the things that I'm struck by, and I didn't talk about this because my husband thinks this is like my crazy historical conspiracy theory, but it's not, it's true. Frederick Douglass is really close to both John Brown and to William Lloyd Garrison, right? Douglass writes that John Brown Constitution with John Brown, but in public, the same months that he's behind the scenes writing that Constitution, he comes out in public and says, you know what? I was thinking that the Constitution was a bad document in the past, but I was totally wrong. The Constitution is actually like amazing, and we can make it anti-slavery. And so part of what I do think was a sort of intentional move was these white abolitionist leaders whose position in the society were more secure take a more radical position, enabling somebody like Douglass to come out with a more moderate position, elevating Douglass's voice in American public discourse. And I think we have Garrison and John Brown directly to thank for the influence that Frederick Douglass was able to have, because they helped to make him look like a moderate. It's also always the case that, immoderate people make sort of like, very radical people make like slightly less radical people all of a sudden look reasonable. And I think there's an important impact there. I would also sort of say, just because I'm, do American political thought, that both John Brown, especially John Brown, transforms American political thought. What he does at Harper's Ferry makes everybody rethink everything. Douglass writes about him, Thoreau writes about him, Emerson writes about him, Du Bois writes about him. You cannot think about conscientious objection to moral evil in this country after John Brown without thinking about what John Brown did. And so I think he really changes the way that Americans think about the scope of American politics. And so to me, even though, like I said, he loses in the short term, he's executed, right? He doesn't live to see the day when his dream is realized. What he does really transforms the nation in ways in the long term. I'll stop there. I have more that I could say, but I won't. That was my short answer that turned very long.
Okay, I'm going to start. I guess Rebecca and I will take turns reading the questions from the chat, and I'll take the first question from Tyler Schlegel, who asks, and this is back to Susan's talk, what did Burns do to be put back into slavery? Did he escape slavery and was caught, or did he do something illegal? I think it's a
That's a really interesting question. I don't think that there's any evidence that, I don't know the ins and outs of that story, but I think it's just, I mean, what he did that was illegal was to be a slave who escaped, right? That was illegal. And so, yeah, he had been a slave and he escaped, and that was sufficient for the federal authorities to send him back to Virginia.
Can I follow up a little bit on that and ask about the timing of the passage of the Fugitive Slave Law and the efforts to enforce it? Was that because the federal government wanted all the escaped slaves to be brought back into slavery, or is it because they wanted to keep try to placate the South?
I think my reading is that they wanted to placate the South. I don't know, again, like I don't know the deep history here, but my understanding is that there is evidence that plenty of the people who are in the federal employ are sort of despondent about what they're ordered to do, right? And yet, they're enforcers of the law. So that's my read, is that there's a kind of attempt to placate the South there.
Becca, you want to take the next one?
Sure. So this is Kennedy's question. Hi, Kennedy. You had a couple of questions here. I'll go with your first one, which is, sorry, I have a hard time reading the actual type, so I'm bringing it up in a bigger document. So I think that this question is about your suggestion, Dr. Barndt, that there's this portion of the 14th Amendment that says that the federal government will or shall come in to enforce voting rights in states if they're not respected. Kennedy asks, do you think that it is possible for that portion of the 14th Amendment to be brought up in the context of Georgia and concerns about voter suppression?
Well, Kennedy, that's a really great question. And part of the reason that I mentioned the clause in this 14th Amendment is because there's so much concern about voter suppression right now, and I don't think most Americans know that those words are in the Constitution of the United States, right? If I were, and this is not, I'm not in the me, like at sea point in my life right now, but I would be making t-shirts that put that language of the 14th Amendment, and I would be selling them and wearing them all over a lot of states in the country right now. I do think, and I'm sure it has been done many times. I'm a scholar of political theory, not of constitutional law. I'm sure it has been cited many times in voter suppression cases, but I think that part of, even if constitutional lawyers and jurists and political scientists know that that clause is there, most Americans do not, right? And the primary way that, not the primary way, one of the way that rights are denied is if people don't know what their rights are. And so you're reading correctly into this talk that I was sharing with you some information that I think that many of you might want to share with others. There's nothing in the subsequent amendment to the Constitution that takes that language out or mutes its importance. Think about it this way. That language has equal standing to like the right to bear arms in the Second Amendment, to the right to free speech, to the right to a free press. It's there, right? It's got an equal power there. And Americans should know that 14th Amendment absolutely as well as many Americans know the Second Amendment. It's probably telling that we don't, but it wouldn't be hard to at least push the needle on that amendment.
Okay, I'll take the next question, and this is about the 13th Amendment from Ashrakat Hassan. So there's a clause in the 13th Amendment that indicates that those convicted of a crime are considered slaves of the state. Do you have thoughts on that?
Yeah, right. So the 13th Amendment says this: neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction, right? So a lot of scholars, especially the sort of in the prison abolitionist movement, have said, look, this is how you link the contemporary carceral state to the tradition of slavery, because we replace, if you've read, a book like Angela Davis's Our Prisons Obsolete, right? This part of the 13th Amendment is a lot of where she's rooting her argument. I would say there's a real difference here in terms of what the 13th Amendment is saying versus legal slavery before the Civil War, which is that there was no language of due conviction, crime, right, there. Now, we all know that a lot of Southern slaves, after the 13th Amendment was passed, read it to say, oh, hello, Black person walking down the street. You have now been committed of the crime of walking down the street, and now we're going to subject you to involuntary servitude. So absolutely the 13th Amendment has served, right? Served especially in the South, especially in the post-war years, arguably to the present day, to sort of continue white supremacist politics. That said, I think the actual text of the amendment, right, isn't enabling slavery, right? What it points us to is that we should have a ethical, moral, just judicial system. And that's where I think, in some ways, a lot of the Black Lives Matter movement is focused, right? Appropriately so, right? I don't think there's a need to undo the 13th Amendment. I think there's a need to, live up to an appropriate, reading interpretation of the 13th Amendment. My sense is that to some degree that was there because they were trying to say, okay, we shouldn't have slavery. And then states were like, but we need to be able to like lock people up when they commit crimes, right? And so they put it in there, and probably Southern states were not so above board in how they plan to use that. But I think that's how it got in there.
Great.
Rebecca?
Yes, I am going to go on to Heather's question since you got one in, Kennedy, already, which is, do you believe that Garrison would hold the belief that it is okay to tear down statues of history now? Like I'm assuming Confederate monuments.
I love that question. And part of why I love it is that, I haven't even been thinking about the burning down. I mean, I live in California. We don't have statues like to anybody because we care only about ourselves in Southern California. But absolutely, I think that Garrison would have held the belief that it's okay to tear down statues. That's in part because Garrison was a showman, right? Like he got attention for doing stuff that got attention. And I'm sure that that's, I'm sure that he would be part of doing that now. I have no doubt that he would. Certainly John Brown would have happily done that. And I think it's certainly true that in point of fact, right, like the pulling down of statues it makes people angry. It can even make people violent, but it does, in fact, in point of fact, catapult public conversation about who we are, who we choose to honor, why we choose to honor them. And in the spirit, at least of this talk, right, I think it's unarguable that Garrison and Brown and other abolitionists would be behind that.
Okay, I'm going to ask Jocelyn G's question. Do you consider the BLM and their criticism of the structural foundation of the U.S. in its treatment/relationship of disenfranchised groups to fall under how Garrison and John Brown criticized the Constitution during their time? Or is there a difference between their approaches when pushing for change and reestablishing definitive rights for all? So comparing BLM to the abolitionists.
Well, I mean, the first thing that we should say about BLM is that, they've been around for a long time, right? I was showing my class Spike Lee's movie Chirac this week, which is like more than 10 years old. And my students were like, what? They're talking about Black Lives Matter 10 years ago, right? But my students hadn't really realized that BLM's been going on for a relatively long period of time. It's very diffuse. I always want to be careful about saying like, this is the thing that BLM does because it encompasses a lot. I actually think that in general, though, Black Lives Matter is much more moderate than Garrison and John Brown were. For the most part, BLM has focused on peaceful protest, election, right? Like, let's elect a more progressive sheriff. Let's, try to work with local officials to change, the terms by which people call police in our community. There is like some movement, like I mentioned in BLM, to like, think about constitutional law and make changes to constitutional law. But even there, and you should look this up, right? Like, Google Black Lives Matter and Constitution, and you'll see some BLM, like sort of constitutional amendment proposals. You'll find them. But I think they're much, they tend to be, I think, much less radical than Brown and Garrison were in their own time. I think the major difference is that the leadership of BLM is largely Black, and I think that makes many Americans, particularly white Americans, read them as radical. But when you, in fact, like look at the policies, I think it's actually a pretty, moderate movement, or certainly compared to Garrison and Brown.
Rebecca?
So this question is from Tana. Hello, Tana. She asks, do you believe that the American people have forgotten our influence on the government and our power in amending the Constitution? Or is there a blatant neglect of the voices of citizens even though they are trying to speak out? Good question.
Yeah, that is a great question, and it's a hard question. I think that what I said before probably answers it in part. I really do believe that the American people, we don't talk in terms of constitutional amendment very much, with one exception, which is that we've had for the last 10 years or so, a kind of increasing conversation around the possibility of amending the Electoral College. And my suspicion, if you want, now, I should say this too, the political scientists know this, right? Political scientists never trust a prediction that a political scientist makes about politics. They're terrible at prediction. That's why we say in our department, we don't call ourselves a department of political science, because we have no scientific power to like do anything. We just study politics. But if I had to make a prediction, one sort of predictive possibility would to say, depending on what happens in this election, if there's a kind of upswell of movement toward the like amending of the Constitution to change or abolish the Electoral College, I think that that could kick off, as we've seen this happen in American history in the past, a period where Americans are like, wait, if we can change the Constitution to do that, why couldn't we change the Constitution to do something else? In fact, like a kind of rediscovery of that whole register and possibility in American politics. Russ Muirhead, who's a political scientist at Dartmouth, has suggested something like that, you know, that could be a possibility. I do think that, you know, there's some neglect of the voices of citizens, and yet, you know, it's just, I'm not sure that's intentional. It's a really big, impersonal, overwhelming society. If we had a Congress, like, so you know that in the original design of this nation, there was like, okay, we need to have one representative for every, you know, such amount of people, because that representative can't be beholden to more than this amount of people. If we actually still paid attention to that, like, recommendation of like the ratio of representatives to citizens, we have a Congress of something like 60,000 people. I can't remember, right? So our representatives are asked to do an impossible job, which is to represent millions of people at a time, and they're going to fall short because of the math. I think there's a little bit of a both and there, but I probably lean toward the first answer as more explanatory.
Okay, I'm going to ask the last question, and I'm going to pose it to all three of our panelists. So to give Susan a bit of a break, and to give Ben and Rebecca a chance to speak on this very general question that I think is a very important question. It's from Ashrakat again, and I apologize to Kennedy for not getting to his second very good question. I'll ship it along to Dr. Barndt, and she will, I'm sure, be generous in her answer. But this is the last question because we are running out of time. Ashrakat asks, although our political climate isn't necessarily on the verge of war and isn't as divisive as it was in the 1850s and 1860s, could you concede that there is a lot at stake this election in terms of where the country is headed? We're having a war of ideas here, and it is a worrisome issue. What do you think? And I'm going to start with Professor Kleinerman.
That's a big loaded question. I mean, I don't think there's any way of, so I'll start with I don't see war coming. Unlike 1860, when the election looked like it could bring war, I don't think we're going to see a 2020 or 2021 war, but, you know, I'm a political scientist, so I too could get it wrong. Hopefully I'm not wrong, but I don't see war coming. As to what's at stake, I mean, I think, you know, in a way a lot is at stake, in a way only one person is at stake, because I'm not sure the ideas of Trump are what matter in terms of the opposition to Trump. Instead, it's Trump as a kind of phenomena of demagoguery in American politics, and whether we accept that going forward, whether we accept something like a political party with no stance other than that they support the president, no matter what he does, or we reject that notion of politics and move back in the direction of something that looks vaguely more constitutional. That's at stake. But in terms of, I mean, the Republicans in a way don't stand for anything other than Trump. So I don't think there's a war of ideas between Democrats and Republicans. There's just a war between, there's a sort of Trump is at stake. So that's my take on the issue.
Thank you. Rebecca?
Well, I guess I'll play the contrarian here, which is that I am worried. I don't think that the vast majority of Americans have any interest in taking up arms. There are, however, fringe elements on both the left and the right that are taking up arms and that are interested in such things and have a taste for it. And my concern is not about them per se, because if they are confined to the fringes where they belong, we're okay. There's always crazy people. We've survived centuries with crazy people who are loose cannons. But it does worry me that, according to my very rough count, about 70% of Americans think that 35% of their fellow citizens are either heartless or crazy, like that they're defective somehow in mind or heart. And that does cause me some concern. And as long as I've been in political science, we've been talking about polarization, but all the evidence suggests that it is worse than it was 10, 20 years ago. And it worries me that we will look at whatever the crazy people are doing and look at it only through the lens of, are they on my side or the other side? Even if we're not ourselves having any interest in taking up arms. So I don't fear civil war is on the way. I don't want to, I'm not being a doomsdayer here or apocalyptic, but I'm much more worried than I have been in my day.
Susan?
So let me answer it in a kind of indirect way that has some sympathies to Ben's answer and some sympathies to Rebecca's. As far back as we have polling of the American population, right, so basically the last 100 years, there have been almost consistently about 30 to 35% of the American citizenry that like support some kind of authoritarian vision, right? Like that's about the level of support that Father Coughlin had. That's about the level of support that Joe McCarthy had. It's essentially about the level of support that President Trump has. That contingency of the American population, right, as a percentage of the population is impressively stable over time. The only thing that's different about now from those times is that in those times, the political party apparatuses were strong enough to keep those people out of public office, and particularly the presidency. So I don't worry about war, for the reasons that Ben say, even though I do worry like about any time there are people taking to the streets with guns and pointing them at their fellow citizens and human beings, right? Like but I don't worry about war. What I worry about in terms of this election is what's in particular going to happen to the Republican Party. The Republican that Trump ascended proves to us that the Republican Party effectively had stopped to exist in a meaningful way before 2016. Certainly their failure to be able to articulate a platform suggests a kind of party collapse. And I think that parties have played an unappreciated role in American politics in helping to moderate, guide, and set terms for civil discussion. I'm always struck, yes, there's polarization between Republicans and Democrats, but the bigger story is that fewer Americans now than ever identify as Republicans and fewer Americans than ever identify as Democrats. Most Americans either identify as independent or are totally like checked out. So what we see so what we see as polarization actually to me suggests like a deeper problem, which is that the parties aren't strong enough. The parties have failed to convince most of Americans that they're worthy of allegiance. And that's the kind of problem that I'd encourage all of you to think about going forward. I really want to say though, it's nice even to see a few of your faces. I wish that I could talk to you longer and in person. I'm going to just put my email in the chat if any of you have follow-up questions, especially students, especially if extra credit is at stake for one of your classes. Please feel free to email me and I'd be happy to be in touch.
Thank you, Susan. Thank you, Ben. Thank you, Rebecca, for this most stimulating Zoom conversation. There is such a thing as Zoom fatigue, but I felt it less here than I usually do. And I have to apologize. I was remiss in starting the recording until Susan started speaking, and then I scrambled and started it. So I'm not going to repeat the introductions. These are all wonderful people. You've seen them in action. I will only repeat one thing, which is the thanks we owe to the Jack Miller Center for funding this opportunity to exchange views across the country. And thank you again for all of you who came. Thank you to the speakers. And Constitution Day isn't until Thursday. but we're permitted to commemorate it early. And so happy early Constitution Day, and wish everyone a good evening. Thank you so much.
Thank you.
Thank you, Joe. That's the
Thank you. And end the whole thing and then do the recording. End meeting for all. Bye.
Hey, Carl.